All right. Well, hi, everyone. Welcome. I'm Andrea with BAMBiz, and we offer marketing for elder law and estate planning attorneys. And today we have invited a special guest that's covering a very important topic, how to handle IRAs in pre-crisis and crisis situations. So Amber has over 15 years experience as a Medicaid and long-term care planner. She has an immense passion for helping attorneys, advisors, and their clients regarding financial strategies designed to help pay for long-term care costs in both pre-planning and crisis Medicaid scenarios. So y'all are in very good hands today, and I'm going to go ahead and turn it over to you, Amber. Thank you.
Thank you, Andrea. Thank you for the opportunity to be here today with everybody. And thank you for that introduction. As Andrea said, we're going to be talking mostly today about pre-crisis and crisis planning as it relates to how to plan with clients' pre-tax or IRA accounts. So if we look at how Medicaid planning is defined, we're really looking at either spending down or otherwise protecting a person's assets so that he or she can financially qualify for Medicaid qualification by spending down or transferring their assets. Medicaid planning can be divided into two types of accounts, pre-crisis and crisis planning. So if we look at the different types of planning in pre-crisis or pre-planning for long-term care, we have a client that is not yet in need of any immediate long-term care services. So they're still pretty healthy. We don't anticipate them needing long-term care for some time yet. Pre-planning is always going to be the best option to help your clients, because clients have more options in a pre-planning scenario as to where they want to receive care and also how to best preserve their assets for the future. If we think about any type of crisis scenario, whether it be planning to go out of town last minute or crisis planning for retirement, that's always going to be a lot more stressful, and clients have less options in a crisis scenario. So pre-planning is always going to allow your clients to have the most options and to preserve the most amount of their assets. From a legal planning standpoint, pre-planning or crisis planning generally involves transferring many of your clients' non-qualified assets or post-tax dollars into an irrevocable trust and waiting out the current 5-year look-back period for Medicaid qualification. All states other than California currently have a 5-year look-back for transferring assets. So the irrevocable trust is a great way to get clients started early to start preserving their assets or protecting their assets. But this can be very problematic when the majority of clients' assets are in pre-tax accounts, because we can't transfer pre-tax accounts into an irrevocable trust without triggering significant tax consequences. So that's one of the things that we're going to be addressing today. Pre-crisis planning may also involve long-term care insurance, and long-term care insurance can be basically in two different camps. It can be traditional long-term care insurance, which is similar to your auto and home insurance, where there's not any cash value that is accumulating within a traditional policy, or it can be a hybrid policy or an asset-based policy, which is combining a life insurance or annuity policy with a long-term care contract. You'll notice, though, in order for somebody to qualify for long-term care insurance, they must be insurable, which we're going to talk more about what that actually means. They can't need assistance with activities of daily living right now in order to qualify. If we then look at crisis planning, we're generally going to be looking at qualification for Medicaid, and sometimes veterans benefits come into play as well. On the crisis planning side of things, clients are already in need of assistance with activities of daily living, or they're anticipated to need those services very soon. So we don't have 5 years to wait. So we can't start transferring assets into a trust because we want to experience immediate Medicaid or VA eligibility for a client that is in crisis mode. There's various planning strategies that can be used in a crisis mode, but it generally is going to involve spending down countable assets into non-countable assets so that we can financially qualify for Medicaid or veterans benefits.
Amber, we had a quick question come in.
Yes.
What is California's look back period?
Currently, they have a 30-month look back. So whether we are pre-crisis planning or crisis planning, one of the most difficult accounts to plan for are qualified or IRA accounts. So any type of pre-tax account that a client has not already paid taxes on, this is going to be the most difficult type of account to plan for, whether we are in pre-crisis mode or in crisis mode. As we know, there's 10,000 baby boomers that turn age 65 each day. That's over 300 per hour, and that's going to be 73 million over the next 10 years. This group of baby boomers currently controls the majority of the $29 trillion of qualified or pre-tax accounts out there. The different types of accounts that are included in the 29 trillion of qualified accounts include traditional IRA accounts that clients set up, 401ks, 403bs, 457s, and thrift savings plans. So depending on where your clients have been employed, they may have a 403b if they were in education, or a 401k with any type of public company that they would work for. But this qualified account group of 29 trillion is going to include any type of retirement account that has not already been taxed, so any pre-tax account. Qualified accounts have doubled since the year 2000, and since 2007, qualified accounts have increased by $18 trillion. If you've been practicing in estate planning or elder law for a while, you've likely noticed that the type of accounts as far as assets and your client's income have changed drastically. It used to be that many baby boomers would have pension checks and Social Security that would help pay for long-term care expenses. You're likely not seeing a whole lot of clients that come into your office that have a healthy pension because it's not all that common anymore that clients are going to have a pension that will help pay for long-term care expenses. Many attorneys are finding that their clients are cash poor or non-qualified poor and qualified or pre-tax rich. This is going to change the strategies that we as financial advisors and attorneys can employ to help our clients. When we look at Medicaid planning and qualified accounts, each state is different as far as how IRAs are treated for Medicaid planning purposes. So states are going to take one of the three following approaches. They're either going to completely exempt the IRA and consider the IRA to be non-countable, meaning that it is not an asset that is going to prohibit a client from achieving Medicaid eligibility if you reside in a state that the IRA is exempt. Other states consider an IRA to be exempt if the IRA owner is receiving their required minimum distribution or receiving regular systematic payments out of the qualified account. And then finally, what most states do is completely count the IRA as an available resource or an available asset. So this is going to be countable for purposes of qualifying for Medicaid benefits. It may be different as far as how your state treats the community spouses qualified account and how they treat the institutionalized spouses qualified account, meaning that it may be countable for one spouse and non-countable for the other spouse. States where qualified accounts are completely exempt for qualification purposes, this makes planning pretty easy in those states because you really don't have to do a whole lot of spend down planning in order to get your client eligible for Medicaid in states where the account is completely protected or non-countable. But before we get too excited about the fact that some states consider the account to be completely exempt, there's currently only 2 states that completely exempt the community spouse and institutionalized spouses qualified accounts for Medicaid qualification purposes. States where the qualified account is exempt if receiving required minimum distributions or receiving systematic payments. This is going to be a pretty easy state to plan in as well. If the client is over 72, then they would already be receiving their required minimum distribution. So that income that's being generated off of the qualified account or off of the IRA is going to make the account value exempt for Medicaid planning purposes, and only the income as accountable income stream to the client. If you have a client that is under the age of 72 and you're trying to qualify that person for Medicaid, or it may become, they may need Medicaid in the future, most states allow for you to just make the payments systematically the same or a consistent payment on a monthly basis, and that will consider the account to be non-countable as well. Only 9 states treat the qualified accounts this way, where the account is exempt if receiving the required minimum distribution or systematic payments. So the most common approach is that states are going to consider the retirement or qualified account to be a countable resource. Currently, 40 states treat the qualified account this way. And planning, of course, is going to be the most complicated in states where we have the qualified account being considered an available or countable resource, because we have to figure out what is the most tax efficient way to spend down that resource and also get the person on Medicaid as well. The next 2 slides are showing a map of, first, the institutionalized spouses' retirement accounts, whether they are countable or exempt. The states that you're seeing in orange are states that consider the IRA to be an exempt resource, either completely exempt or exempt if the person is receiving their required minimum distribution. And all of the states that are in white are states that consider the qualified account of the institutionalized spouse to be a countable or available resource. So as you can see here, with most of the United States being white, most states are going to consider the institutionalized spouse's IRA account to be countable or fair game that needs to be spent down before the person is eligible for benefits. This slide here is showing the states that consider the community spouses' retirement accounts to be countable or exempt. And again, all of the states that are in white are states that consider the qualified account to be countable, and the states that are in orange are the states that consider the qualified account to be exempt. So Pennsylvania and Wisconsin are an example of 2 states that consider the community spouses' qualified account to be protected, so we don't have to spend that down in those states, but they consider the institutionalized spouse's account to be an available or countable resource. And so that's something to keep in mind, that just because one spouse's IRA account is exempt does not necessarily mean that in your state the institutionalized spouse's qualified account is exempt as well. So if you have a pre-crisis planning case and you're trying to deal with retirement accounts for the client, I've outlined 4 different options that clients may consider. The first option is to leave the account as is, or just leave it intact, especially if you are planning in a state that does not consider the retirement account to be a countable asset for Medicaid planning purposes. The second option would be to liquidate the account gradually, pay the taxes over several years, and then shift the net proceeds into an irrevocable Medicaid trust. The problem with doing that gradually is each time that the transfer is made into the irrevocable trust, that is likely going to trigger a new 5-year look-back period if you're in every state other than California. The third option would be to consider using a hybrid long-term care insurance policy. And this is the type of policy that I mentioned that is combining either a life insurance or annuity policy with a long-term care policy. And then the fourth option would be to use a combination of options 2 and 3 that you're seeing here. So if we look at a pre-crisis scenario, we're going to look at a situation where we have a married couple where both spouses are healthy. We have an example of Tim and Patty, and the case facts are that Tim is age 65, Patty is age 60. They're both recently retired, active, and very healthy. They recently attended your workshop on asset protection and Medicaid. They're very concerned about long-term care, and they would like to leave an inheritance to their two boys if possible. They liked the idea of doing an irrevocable trust as a way to protect assets from long-term care spend down. And if either spouse gets sick, they would like to remain at home as long as possible because Patty is frightened by the idea of going into a nursing home. If we look at their financial situation, they currently have monthly income of around $5,000 per month. They have monthly expenses of $3,000. They have a home that is valued at $500,000, stocks and bonds valued at $300,000, a checking account at $50,000, and then we can see that their largest account is Tim's IRA that is valued at $1 million. If we look at a hybrid long-term care insurance solution that we could recommend to this couple, we could transfer around $250,000 through a tax-free transfer of Tim's IRA. So we're not going to transfer the full $1 million IRA account into this hybrid policy, but we would just take a portion of it at $250,000, leaving $750,000 remaining at the current custodian. When we transfer the $250,000 over to a hybrid policy, this is going to equal a second to die life insurance policy that has a death benefit of $272,000. And it's really attractive from the standpoint of it's going to offer Tim and Patty a lifetime of long-term care benefits for each of them. So this is a really unique situation where we can use one spouse's IRA account and we can provide an unlimited lifetime long-term care pool for both spouses. So what that looks like as far as the long-term care benefit for each spouse would be around $8,200 per month per spouse. And this is going to be available to help pay for care in the home, in assisted living, or in a skilled nursing facility. It also offers the ability to have the clients, basically the account remains completely liquid, where they can request a full refund of premium if they ever decide that they do not want this policy anymore. So the insurance company that offers this type of policy is the only one right now that allows for us to use qualified monies from one spouse's IRA and add the other spouse on there as a joint insured so that both spouses can draw from the policy for long-term care. And it also allows for a lifetime of coverage. Most long-term care insurance policies are only allowing like a 3 or a 5 year benefit period. So it can be really powerful in situations where we have a married couple and we're trying to protect both spouses, and we're trying to do that in a tax efficient way. So how the internal policy works is we would do a tax-free transfer or a 60-day rollover of the $250,000 to purchase the hybrid policy. And over a 10-year period, the insurance company is going to send Tim, the IRA owner, a 1099 for 1/10 of the account value, or $25,000 per year out of the 250, so that at the end of year 11, all of the money is completely tax-free at that point. So you can think of it as an hourglass figure where we start out with all of the money being in a taxable position, or the 250,000 is completely pre-tax. And then gradually over the 10-year period, the money is transitioning from pre-tax over to a post-tax dollar account. So that in year 11, if neither spouse would need long-term care and they pass away shortly after year 11, then the $272,000 death benefit is going to be completely tax-free to the intended heirs. Another option that is looking at the same benefit would be to consider doing a multi-pay hybrid policy. So some clients are in a position where they don't want to transfer a one-time lump sum amount of $250,000 into a policy like this. So they instead could consider liquidating a portion of the IRA each year for 10 years and still get a similar policy that would provide them with an unlimited long-term care pool at the amount of $8,200 per month in the same face value at $273,000 if they never need to use the policy for long-term care purposes. The non-qualified assets in this situation, the client's cash accounts, the home, and other non-qualified accounts could be transferred into an irrevocable trust to start the 5-year look-back period in the event that either spouse needs to apply for Medicaid in the future, and also just to give them more protection in the event that they choose to qualify for Medicaid down the line. Our plan in this case would be better than just self-insuring if we consider a situation where Tim or Patty needs long-term care and we assume that their in-home care is costing $10,000 per month. Their $250,000 that we use to purchase this policy would be completely depleted within a 25-month period. But instead, by transitioning a portion of Tim's IRA into a hybrid policy, the same $250,000 will provide a lifetime of long-term care coverage for Tim and Patty, which would allow them to protect their other assets from spend down. If they have sufficient income to pay for their cost of care, then they're really protecting all the other assets that would not need to be used to help pay for long-term care services in the future. An ideal client for pre-planning or somebody that is going to qualify for long-term care insurance solutions are generally somebody that is under the age of 75, although some policies will issue up to age 80. We need somebody that is considered to be in good health. So this doesn't mean somebody has to have a perfect track record as far as their health goes, but we need somebody that does not already need assistance with activities of daily living. So somebody that is already having home health care services come in or is deficient in any of the activities of daily living is not going to qualify for a long-term care insurance solution. And then generally, if we're looking at a hybrid long-term care solution, we would want somebody that has at least $500,000 in liquid assets, not including the home. If we look at a situation where pre-planning or pre-crisis planning is not an option, we're then forced to do crisis planning or Medicaid or VA planning. Now we're going to look at the same situation in a crisis planning scenario with Tim and Patty. So if we recall in Tim and Patty's situation, we're going to assume that instead of being proactive and pre-planning for long-term care, Tim is now in need of nursing home care and he's being asked to pay $10,000 per month. Patty has been taking care of Tim at home as long as possible, but now he's in a facility and she's worried about running out of money. If we look at the income and asset limitations for Medicaid planning for a married couple, generally from an income standpoint, the spouse that is remaining at home or the community spouse, the well spouse in some states is what is referred to as, they can have unlimited monthly income without having to contribute their income towards the institutionalized spouse's cost of care. The institutionalized spouse's income must be less than the cost of care. In some states have an income cap, and in states that have an income cap, you would need to do a qualified income trust or a Miller trust if the institutionalized spouse's income exceeds $2,350 each month. From an asset standpoint, the institutionalized spouse is generally able to keep $2,000 in resources, and the community spouse is able to keep 1/2 of the countable resources up to $128,640. These numbers vary slightly depending on the state, and I will point out that the asset limitations, if your state does not consider the qualified IRA accounts to be a countable asset, then these accounts or these amounts that you're seeing here do not include the qualified account in these numbers at all. So a couple could have 128,640 of non-IRA accounts, and if you reside in a state that protects the qualified account, then they could have their qualified account on top of the 128,640.
And Amber, I apologize, before you move on, we did have a question about the pre-crisis planning portion of that example with Tim. Why does
Sure.
Tim need to transfer 250,000 into a separate IRA? Why can't the original IRA do the same thing?
So it would need to be transferred into a policy that's issued by an insurance company that offers the leveraging for long-term care. So if the account was currently with Wells Fargo or Raymond James or just in any type of brokerage account, it would not offer the same type of leveraging as transferring it into an actual hybrid policy, which is the whole reason why the account would need to be moved in order to get that leverage. Okay, so going back to our case facts, Tim is now age 75, and after struggling with dementia for years, he's in need of nursing home care. His family believes that Tim could live for another 15 years or until he is age 90. Tim's monthly income is $3,000 per month, and he has a monthly nursing home bill of $10,000 per month. Patty is his 70-year-old community spouse, and her monthly income is $2,000 per month, and her monthly maintenance needs allowance for Medicaid planning purposes is going to be $3,216 per month. Together, the couple has a home, car, prepaid burials, and $600,000 of countable assets. But of that $600,000, $500,000 consists of Tim's IRA account. The goals in Tim and Patty's case would be now to obtain immediate Medicaid eligibility without any kind of penalty period. And we also want to minimize the tax burden for Tim. The other goal would be to provide Patty with peace of mind as well as sufficient income and resources to maintain her lifestyle within the community and also avoid long-term care placement for her. If the couple does nothing and they're spending $10,000 per month on Tim's care, they're going to exhaust their $600,000 in assets within a 60-month time frame. When Tim passes away, Patty is going to be left with limited assets and nominal monthly income. So we want to determine what the spend down amount would be in this situation, assuming the qualified account would be a countable resource in this state. So Tim, the institutionalized spouse, is allowed to keep his personal property, a prepaid burial policy, and $2,000 of the $600,000. Patty, as the community spouse, is able to keep the home, car, her personal property, a prepaid burial policy, and $128,640 of the $600,000 in cash assets. So when we deduct $130,640 from the $600,000 in cash assets, we see that the spend down amount equals $469,360. The most problematic asset in this case is the fact that most of the spend down amount is consisting of Tim's qualified account valued at $500,000. If this was a case where we had all after-tax dollars, it would be a simple solution to get the money from Tim over to Patty and achieve immediate Medicaid eligibility. But in this case, because most of the, or all of the spend down amount is in a pre-tax account, we need to be cognizant of the fact that it would cost this couple a whole lot of money to cash in the IRA account and still achieve Medicaid eligibility for Tim. So we're trying to do the most cost-effective, tax-efficient planning in a situation where the institutionalized spouse owns a large qualified account. So first, we want to determine if the qualified IRA account is going to be considered a countable or available asset in the state. Second, if the account is countable, we would consider one of the following options. So the options that you're seeing here on the screen are options if the institutionalized spouse owns a retirement account that is considered to be countable in your state. The first option would be to liquidate the IRA, pay the taxes, and purchase a non-IRA or a post-tax dollar Medicaid compliant annuity owned by the community spouse. In this case, the couple would be paying all of the taxes up front in order to get the after-tax monies over to the community spouse. And if you live in a state that allows for promissory notes to be used in a Medicaid planning context, you could also consider a promissory note instead of an annuity in this case. The second option would be to do a rollover or a transfer of the IRA account for the benefit of the institutionalized spouse and have the institutionalized spouse be the payee of the Medicaid compliant annuity. The advantage of doing option number 2 is the fact that by using an IRA Medicaid compliant annuity, we are preserving the pre-tax status of the $500,000 IRA account and converting that into an income stream so that Medicaid is not going to consider the account to be available at the point that it is annuitized or converted into an income stream. The third option would be it's a similar solution to option number 2, is to use name on the check rule, which would mean that we are doing a transfer or a rollover of the institutionalized spouse's IRA, and we would name the community spouse as the payee of the Medicaid compliant annuity. This is a somewhat risky strategy that we'll talk more about as far as the differences between option 2 and option 3, but the process would be the same, where we are transferring the IRA from a countable account and transferring that into an IRA annuity that is still owned by the institutionalized spouse, so that it is considered to be a like-to-like transfer. We're not changing ownership of the IRA, but then we would name the community spouse as the payee instead of the institutionalized spouse as the payee. And then the fourth option would be to use a marriage quadro, which is an option in some states to get a court order in order to transfer a qualified account from the institutionalized spouse over to the community spouse. So which of these options is the best? So it depends on a variety of different factors, and some of the things that you would want to consider in a situation like this is the size of the qualified account. So if we're talking about an institutionalized spouse that owns an account that is valued at $50,000, it may make sense to go with option number 1, where we liquidate that account, pay the taxes, and transfer the net amount over to the community spouse. Whereas if we're talking about an account that is valued at a whole lot more, like $500,000, then we may want to consider one of the other options, because paying all of the taxes at one time and transferring that money to the community spouse may not make the most sense in that case. We also want to consider the institutionalized spouse's anticipated longevity. So if we have a situation where a couple is going to go with option number one and liquidate the majority of the qualified account, they're going to pay all of the taxes up front. So we want to consider how long we anticipate the institutionalized spouse actually living in that situation, because we wouldn't want to tax all of the money in 1 year. And let's just say they have a tax bill of $50,000 and then they only receive Medicaid benefits for 2 or 3 months because the institutionalized spouse doesn't live that long. We wouldn't want to move forward with a plan like that, where the break even to get the money back from a tax perspective is going to be a longer period of time than we anticipate the institutionalized spouse living. We would also consider how risk averse or risk tolerant the clients are. As I mentioned, name on the check rule is one of the more risky strategies to try, because not all states consider the income that would be generated off of the Medicaid compliant annuity to belong to the community spouse. So that would be something to discuss with your clients. Also, we would be looking at whether your state recognizes name on the check rule and or in marriage quadro. In marriage quadro is another planning strategy that is not necessarily favorable in all states. So that's something to consider. And then how much time we have to implement the plan. Converting a qualified account into a non-qualified account or a post-tax account is going to happen pretty quickly, as well as to annuitize IRA account into a Medicaid compliant annuity is going to happen quickly, whereas in marriage quadro can take anywhere from 3 to 6 months to actually get that in place. So if we're looking at doing planning quickly, then we may not want to consider a marriage quadro in those situations. If we instead, if we have a fact change where we instead consider the $500,000 account belonging to Patty instead of to Tim, Patty is the community spouse, and so the planning becomes a whole lot easier if the qualified account is owned by the community spouse instead of the institutionalized spouse. The community spouse is entitled to have unlimited monthly income without having to contribute their income towards the institutionalized spouse's cost of care. This is true in every state other than New York and Illinois. Those are 2 states that if the income of the community spouse is a certain amount, then they would have to contribute some of the income to the institutionalized spouse's cost of care. So if we look at eliminating the $500,000 qualified account that Patty owns, we could do an IRA transfer or an IRA rollover into a $500,000 IRA Medicaid compliant annuity. This would work in the situation where Patty is the current IRA owner, because it would need to be a like-to-like transaction. And so if we look at how the annuity would be structured, with Patty being 70 years of age, her Medicaid life expectancy is around 16.5 years. And so the maximum life expectancy that we would recommend in this case would be 198 months. The annuity could, or in this case, based on the life expectancy, would create monthly income of $2,600 per month, so that the total payout on the annuity is $514,800. So that's going to be slightly more than the amount going into the annuity, and this is just representing a small amount of interest that would be paid over the life expectancy of Patty. So by doing an IRA Medicaid compliant annuity that's owned by Patty, she can have unlimited monthly income in this case. So after the annuity purchase, she is going to have around $100,000 of cash assets in her name, because the couple had $600,000 of total assets and we annuitized $500,000 of her qualified account. She will then have monthly income of $4,600 per month. And this is consisting of her Social Security at $2,000 and her Medicaid compliant annuity payment at $2,600 per month, so that Tim's copay to the nursing home is going to equal all of his monthly income at $3,000 less his $50 personal needs allowance, so that he's paying $2,950 towards his cost of care. If we look at how Tim's monthly Medicaid copay is determined, we would first calculate Patty's monthly income. Patty is the spouse that is remaining at home, and she's going to have $4,600 of total income. We see that in this case, because Patty's income exceeds her monthly maintenance needs allowance at $3,216, she is not going to receive any of Tim's income from a shifting of income over to her, so that Tim's copay to the facility is going to equal his Social Security at $3,000 less his $50 monthly needs allowance, and that is where we're getting the copay amount of $2,950. So if we were in a situation where Patty's income was less than the $3,216 or her MIMNA, then she is going to receive some of Tim's monthly income to make sure that she has sufficient income before determining what his copay to the facility would equal. The economic results of doing the Medicaid compliant annuity for Patty is that they were expected to pay $10,000 a month for his care. We were able to reduce Tim's copay down to $2,950, so that the couple experienced monthly savings of $7,050 per month. What all of this means for you is that you should have a constant client base, because long-term care is expensive, and it is also complex from the standpoint of Medicaid planning and clients that have large qualified accounts. Clients really have no choice but to seek help from an attorney in situations where their cost of care is significant and they're worried about running out of assets, whether it's a pre-crisis situation or a crisis situation. The types of solutions that we offer is in a pre-crisis planning situation, we would offer hybrid or asset-based long-term care strategies like we discussed in the first scenario. We also offer annuities with enhanced income riders and life insurance with chronic illness riders. These are all types of policies that in most cases the clients would still need to be insurable or healthy enough to qualify for these types of policies. And then in a crisis planning situation, we offer Medicaid compliant annuities, whether they're owned by or if they're funded with after-tax dollars or IRA dollars. And then we also offer prepaid burial plans that are exempt for Medicaid planning purposes in most states, and also small guaranteed whole life insurance policies that states will consider to be exempt from a Medicaid planning standpoint as well. Like Andrea mentioned, my name is Hinds, and I created AshBer, and the thing that sets my company apart from other carriers is that we only work with A-rated insurance providers when we are working with Medicaid compliant annuities, as well as pre-crisis hybrid long-term care insurance policies. I have been working with elder law and estate planning attorneys for the last 15 years to help their clients qualify for Medicaid. And we all offer complimentary case analysis, so we can help you to determine the optimal annuity amount, the term that should be considered for the annuity, and what type of assets that your clients may consider annuitizing in order to achieve Medicaid eligibility. And with that, I'll answer any questions that people have.
Okay, perfect. Well, thank you, Amber. That was a very informative presentation, and we had a couple questions come in already. I think you answered them as we went along. I don't see any others right now, so if you have any Amber's email's on the screen here, or feel free to reply to the email that you were sent with the link to this presentation, and we'll make sure that Amber gets those and can answer those for you. So with that, we will call it a day. Thank you so much, Amber, again, and thanks everybody for joining us.
Thanks, Andrea.
Have a great day. Bye-bye.